Choke, no joke. Yeah. It's choke, no joke. Let's go. Choke, no joke. Chicken choke, no joke. Choke, no joke. Niggas choke, no joke.
Thank you. All right, Mr. Shart, you had questions for Mr. Sprinkle? You can be seated.
Thank you, Your Honor. Oh, Your Honor.
Yes. Oh, yes, thank you. Ladies and gentlemen, so before we broke for lunch, there was some discussion with this witness about comparing defendant Stillwell Exhibit 44, which was a picture with a State's Exhibit 510, which was essentially the same picture. And there was a little box. And I just wanted to let y'all know that there was nothing in that box at the time it was introduced into evidence, because at that time it hadn't been established what the box meant or if what was in the box could come in or anything like that. So that's the reason that there was nothing in that box. There's not anything nefarious about that. Okay. All right. Just want to let y'all know that. Okay. Go ahead, Mr. Shart. Thanks for the reminder.
Your Honor, permission to publish DS 44?
Yes, you may.
Actually, you know what? 510Y. Do you have 510Y? Okay, DS 44.
You may.
Your Honor, may I approach?
You may.
Okay, Mr. Sprinkle, I am handing you State's Exhibit 510Y and Defense Exhibit DS 44.
Okay.
Okay, we can agree that that is the same picture?
Yes, the photograph is the same. The stuff around the photograph, the frame and whatnot is different.
Okay, and that photo is also on the screen, correct?
Yes, the DS 44 is on the screen. That's correct.
Okay. Now, I want to get this right as far as what your testimony is. You've been to the exterior of the Sky House, correct?
Yeah, I've been outside the Sky House.
As part of this investigation or another investigation?
It was this investigation.
Okay. You've never been inside the Sky House or inside the units?
No, I've never been inside one of the units.
Okay. Is your testimony that this is a picture of Shannon Stillwell in the Sky House or not?
I believe that it is, though I've not been inside the Sky House. That was my recollection from everything I put together, that was him standing inside the condo at the Sky House that evening. But if you were to ask me, like, if I stood where he is standing in this picture, no. So I can't say with 100% certainty now.
Okay. Now, in States 510 Yankee, I believe it is, there's a date and time on that photo, correct? On that exhibit?
Yes.
Okay, what is the date and time?
January 10th, 2015 at 9:58 p.m.
2015 at 9:58 p.m. Okay. Now, that is the date where someone posted this photo with this caption on social media, correct?
That's correct.
That is not necessarily the time when this photo was taken.
That's correct.
In fact, do you know who took this photo?
Well, there was somebody who told me they took the photo. I showed them this photo and they told me they took it.
Okay.
It's written in my report, so if I'm wrong, please let me know, but I'm pretty sure I recall who told me that.
Okay. And were you able to determine when this photo was taken?
I can tell you, all I know is what the person told me.
Okay. You're not, and I don't want to elicit hearsay, but you're not, please keep that up, Mr. Kokomo. You're not telling the jury that this photo was taken on January 10th, 2015, are you?
I don't know when the photo was taken.
Okay. Well, you're familiar with the seasons here in Atlanta?
I am.
All right. Sunsets?
Yes, that's correct.
Okay, 9:58 p.m. on a January evening. You would agree that that photo does not depict what the Atlanta streets would look like at 9:58 p.m. on January 10th of 2015, does it?
No, it'd be dark out.
It would be dark out if that was in fact the time.
That's correct. Eastern Standard Time, it would be dark out.
Okay, so bottom line is, this is Shannon, but we do not know, we don't have any information to say when this photo was taken.
That's correct.
Okay.
Well, I was told when it was taken, thereabouts.
That information, I understand that we're getting back in this hearsay. That information wasn't that it was taken that day, was it?
That's correct.
It was taken another day.
That's correct.
All right. So this photo does not place Shannon Stillwell at the Sky House on January 10th, 2015, does it?
Maybe it does, maybe it doesn't. I don't know. I don't know. Like I said, I don't know when the picture was taken.
Your information is it wasn't taken on January 10th.
That's well, but it was posted on January 10th. But I don't, like I said, I know that's not, I don't know that it was taken on January 10th. If the person who told me something else says otherwise, then it wasn't, or was telling me the truth, then it wasn't.
Okay. Let's talk about, and you can take that down, Mr. Kokomo. You can take that. Thank you. You became involved in this case in January 2016, correct?
Around that time, it may have been a little bit before that, but that was when I really started getting
Okay.
involved.
And I've read your report. You reviewed certain work done by other individuals, correct?
I did.
Okay. Now, my question to you is, were you provided with Detective Thorpe's file,
I was.
his entire file?
Well, I have what he gave me. Was that everything in his file? I don't know. I'm sure I asked him for everything in his file. I hope that he gave me everything that he had.
Do you have his rough notes?
I don't know that I got. No, I don't think I did. If it's not so with me, everything that I receive would be digitized. So if it's not like, in other words, if I were to get something like rough notes, which if he were to just give them to me, which would be unusual, and I would remember something like that, I would have immediately scanned them anyway, and they'd be reduced to digital form. If they're not in the digital case file, then I don't have them.
How about Investigator Dennis and Investigator Gaither? Did they give you case files?
They gave me. I wouldn't go so far as to say well, I guess it depends on what you define as a case file. They gave me cell phone records that I asked for. various videos and cell phone data extractions. I remember meeting with Dennis in particular, at least it would have been multiple times, but yeah, and just sitting at his computer and him just saving things like cell phone records and whatnot to like an external thumb drive. So when you ask me if they gave me case files, it'd be something like that. It would be like data that was pertinent,
Did
like cell phone records, that kind of thing. But as far as like a completed case file, I don't know if I received anything quite like that from them.
did they give you police reports that they authored?
Yeah, I seem to remember they
Did
did.
they ever indicate to you that some of their police reports were missing? That the Atlanta Police Department had lost them?
Oh. No, I don't recall. I don't recall anything specifically about any police reports being.
Okay, y'all. I'm going to have to push this a little forward because something major just happened in the case. And Miss Love just got her culo chewed out by the judge. And I think the judge is getting ready to grant a mistrial.
As we're pulling up 528 Yankee, would you tell the jury what significance you found in 528 Yankee towards your investigation?
Well, there was a phone number posted it was a public post, and there was a phone number that was, there's a comment section to the right of the photograph, and there was a phone number posted by the account holder that appeared to be their own.
And was the account holder Justin Cobb?
Yes.
What was the significance?
I'm going to object to that as hearsay and ask it to be stricken.
Which part?
Part about who the number belongs to.
Sustained.
Okay. What did you do to determine whose account this was?
Well, I looked at the photos that were posted in the account, I believe. And I mean, that would, for the traditionally that's what I would do with an Instagram page. It's just posted in public view.
And what was it that made the number in this post significant to you?
Well, I was looking for a number for Justin Cobb.
And what led you to believe that this number was a correct number for Justin Cobb?
Well, it was, there's probably more to it than just this, but it was posted in this Instagram comment, and
Was it posted by the owner or user of the account?
That was false speculation. I'd object.
Yeah.
If he has a basis to testify.
Are you able to see and tell, looking at the posting itself, what name the number is next to? What
I would
handle
renew
the
my
number
objection
is
and also
next
object on the basis of hearsay if he's reading from a document.
to? It's already in evidence, Your Honor. And,
Okay,
and Your Honor,
when we were up here at the bench,
so, Your Honor, I'll ask additional questions that I think will,
sustained.
okay. So, after seeing this
Your Honor,
number,
I have a motion, please. May we step up?
Yeah. I'm going to excuse y'all to the jury room.
Your Honor, may we excuse the witness?
Yeah, Mr. Smoker, you can go ahead and step outside for us. Thank you.
Your Honor, so
Your Honor.
well, first of all, my motion is a motion for mistrial, based on the actions of the prosecutor. My objection initially to the item was that it contained hearsay. The state represented at the bench that it was not hearsay. There was no hearsay contained in it. We did not address the issue of what the state already knew, which is that there was a phone number attached to it that she was going to try to elicit testimony from this witness about who that phone number belonged to. That is, in and of itself is speculation, but it's certainly hearsay. The document can't authenticate itself. I believe the site for that proposition is Twiggs versus State. It's 315 Georgia Appeals 191. So this witness can't look at a document and say that it says this phone number is from Justin Cobb's Instagram or social media posting. This is who it belongs to. So that was my objection. I believe the objection was well-founded. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it. And based on that, I would move for mistrial.
May I respond?
You may.
Judge,
Can somebody put the document up? I don't see it.
yes.
Would you put it up?
First, the state objects to a mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments with, where's the comment? There it is.
Yeah,
Okay.
the comments generally being all of the writing on the right side of the picture.
Your Honor,
And so I
We-
said to you, is any of it hearsay? Is any of it being offered for the truth? And you said, no.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or this exhibit will prove or show that this is Justin Cobb's phone number.
You're
It-
asking him that? And
No,
asking
Your
him to
Honor, I-
testify to that?
I'm asking him, and I understand the court, I'm asking him
you?
what handle it's next to, and Your Honor, what he did after seeing what he saw on this
That's
social
not what
media
you
page.
asked, Judge. You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it
What is it?
explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because it's a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle. He sought additional information. The
Is
entire
phone
cross.
number one of the comments?
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I
right?
asked at the bench what comments they were asserting was hearsay, Your Honor. I literally
And
asked
I
that.
asked at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkle's actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant to him in this investigation, where his steps and actions are being questioned.
But you know, Judge, we don't get there. I hear what the state's saying, and it's disingenuous because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there and I asked for everything that was on the right side, all of the verbiage to be, I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse.
I asked.
Here. It is what it is. I think that the state was disingenuous about it. State's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm
I
asking
mean, I
for one.
can't figure out what it is. If it's disingenuous, if it is that, I mean, I don't want to malign the prosecutor standing in front of me right now. So I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that, but this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes. I'll have a ruling when I get back.
Woo-wee! The judge gave her some ether. Let's see what happens. She came right back. Let's get right back into it. You ain't got to wait.
For mistrial, it's not as if for mistrial, it's All right, I'm going to deny the motion for mistrial. It's not as if the state couldn't have gotten the testimony in an appropriate way anyway. It's not like the testimony itself is that big of a deal. But I am going to, I'm going to exclude that statement and just tell the jury to disregard the statement and any testimony that had anything to do with the statement. So let's get Mr. Sprinkle back. Did you want to put anything on the record, or are you just getting ready for the jury?
I'd like to put just a matter
Go
before
ahead.
the record for the court.
All right.
Your Honor, this is from United States versus Roberts, Roberts. It's 640F second 255. It's the Ninth Circuit, 1981. It's been cited many times. It specifically says that continued prosecutorial misconduct may show a course of conduct establishing the intent to provoke a mistrial and bring into play double jeopardy considerations. You have not been here the whole time, and we thank you for being here. But starting with opening statement, and I know you got my motion.
I know, and I know what your argument is. Here's the thing is that, and I understand what that law says as well. Ms. Love does not appear to be trying to get a mistrial so that she can try this case over again, which I know if that were what she was doing, she wouldn't be able to try the case over again anyway. So that's just not applicable here. Now, is there continued prosecutorial misconduct merits a mistrial anyway, based on that? Yes, potentially we get to that point at some point. But there is not, from what the court's vantage point is, an indication that the state is trying to goad anybody into moving for a mistrial so that they can retry the case because they think they're losing the case. I think they think they're winning the case.
I don't know what they think, but I will say this. This is not becoming in the state of Georgia of a trial. And it is all the time, all the time. At some point, it's got to end. Because this is not fair to Mr. Williams, and I assume the other people on trial will agree. It is this constant hiding walls, citing law that does not stand for what it stands for, not giving over information, not answering the court, arguing with the court, and I think it does rise to a level now, but I understand what you rule. But I think that we're well beyond it. And the reason I said from all these things is it's literally.
Oh, I saw that. I know. I mean, I think my frustration was apparent a few minutes ago. But I truly am struggling with whether all of this is purposeful or this is just really poor lawyering on the part of members of the state's team. Either way, it's really unfortunate. If it's something other than poor lawyering, then it is more than unfortunate. But at this point, and we're going to just move on with that exhibit being excluded. I don't know if I can stress any more than I already have how much the state's lawyers need to make an effort to be upfront and forthright in the trial of this case. So let's get the witness back in.
Your Honor, would you allow me to either renew my motion for mistrial or consider that my motion is renewed before the asking of the next
It's-
question,
yes,
please?
Yes, it's renewed.
Thank you.
Yes. Thank you. Ladies and gentlemen, upon further discussion, that last exhibit, which is State's Exhibit 528Y, is excluded from evidence. And so that means that y'all need to disregard it entirely in your thoughts and in your deliberation in this case. And as well, you need to disregard any testimony that might have been given about that particular exhibit. All right, go ahead, Ms. Love.
Thank you, Judge. DDA Sprinkle, you were asked on cross-examination about whether you attempted to determine whether Kenneth Copeland, in the words of Mr. Adams, lied when talking to the police. Do you recall that question?
Yes, generally, he asked me something about whether I endeavored to detect that or figure it out.
Did you make any steps to determine or to corroborate the information you gained from Kenneth Copeland?
I did.
Would you tell the jury what steps you took to corroborate information that you gained from Kenneth Copeland?
Well, there was a number of things that I did. I, in particular, looked at all the cell phone records. Like, for example, okay, so I looked at the call detail records, the times that people were called or made calls, the parties to those calls, and also the towers that the handset or handsets utilized by those calls. And as I've testified previously, you can tell somebody's general location based on the tower and the sector of the tower, the antenna of the tower that their handset utilizes to facilitate the call. And also, you can, in knowing who somebody is communicating with at a given time, that can tell you a little something as well. And so when I compared Mr. Copeland's statements to my analysis of the cell phone records, I tried to the best of my ability to corroborate as much of his statement as I could by analyzing all of that.
You were also asked on cross-examination the power went out over here. On all of the screens.
On what? I can't see any of the screens, so
They're black.
the monitors themselves are out. Okay, well, do we need them right now? Do we need them right now?
No, not at this precise moment, no.
So in terms of, is this one on? No. No? Okay. Do we have our backup thing? It does sound like something went silent too, so.
Just to be clear, Your Honor, it's not the monitors that have lost power, it's whatever's feeding the monitors.
Okay. Well, we got the sound fixed, and so now we're gonna have issues with the video, the site. Yeah, I think maybe a breaker got thrown because it sounds like maybe the AC went out, which would make some people happy, I think. All right. I mean, if it's gonna be a few minutes before you get to the next exhibit, you can just go ahead with the testimony, and Ms. Pursfield will see what she can do about getting some sort of monitor backup.
Yes, thank you, Judge. DDA Sprinkle, did you utilize statements from other witnesses to corroborate information you obtained from Kenneth Copeland's interview?
I did.
Citation clause.
Not just from that, so overruled.
You were asked on cross-examination whether you obtained a wiretap for Defendant Williams' phone. Do you remember that?
Yes.
As it relates to the Donovan Thomas murder, would it be something you would expect to be able to get a wiretap for a year and a half later?
On the grounds of speculation.
Overruled.
As it relates to the Donovan Thomas murder?
So wiretaps are for evidence of things that are going to be talked about in the future. I'm trying to think. I don't believe I've ever obtained a wiretap to investigate a crime that happened in the past, solely to investigate a crime that happened in the past. That's not to say you couldn't. I have heard of such things, but I've not personally done it, and I did not do it in this case.
You were also asked on cross-examination about the photographs that depicted, or the social media postings that depicted Defendant Stillwell. Do you recall that?
Yes.
And did you testify that you obtained information about the photograph from a person you spoke to?
Yes. Yes. Apart from what was just, available and in the public internet form, that being the website from which I obtained them. Yes, I did. I spoke with someone about the photograph.
Okay. Mr. Adams asked you about Detective Thorpe consulting with Detective Gaither and Detective Dennis. Do you recall that?
I do.
Do you have any knowledge of whether Detective Gaither or Detective Dennis were consulted with before warrants were taken out by Detective Thorpe? In other words, did he seek their permission to take out the warrants?
No.
Do you have
No.
any knowledge about that?
No, I don't believe he did. No.
You were also asked on cross-examination by Mr. Adams about the dismissals and the NPGJ for certain people that warrants were initially taken out for the murder of Donovan Thomas. Do you remember that?
I do.
Were the dismissals of those warrants in any way based on the additional investigation that you did with your investigator, David White, into the murder of Donovan Thomas?
Well, no, not the one with Sledge. That was the Mr. Antonio Sledge. That was the preliminary hearing judge that threw that one out.
Mhm.
So,
Did you,
Hang on. All right, I don't know if your mic's on at all, but
I'm sorry, it was non-responsive and it was testimony about other court proceedings, which I believe is inappropriate and hearsay.
overruled.
did your investigation into the murder of Donovan Thomas lead you to present MPGJs for people who had been arrested for his murder?
well, yes, for the people that for which we didn't, the people that we didn't prosecute for the murder, yes.
Mr. Adams asked you specifically about corroborating the information you gained from Kenneth Copeland's interview. And specifically, he asked you about phone calls with Demikian Garlington. Do you remember that?
Yes.
Are you able to tell the jury what information Kenneth Copeland provided you that you were able to corroborate?
Well, well,
Okay, I think your mic's still out, but sustained.
You were asked on cross-examination by Mr. Shart whether Kenneth Copeland said he was at the Green Store at the time of the murder. Do you recall that?
I do.
When you are looking at cellular location information for cell phones, do you look at a static point in time to determine what a person's handset is doing? In other words, do you only look at the time of the incident in question, or is the time leading up to it and the time after it also relevant?
Well, yes, the times before, during, and after the homicide, it can absolutely be relevant.
Was there any point during your investigation where Kenneth Copeland said, "I was at the Green Store at the time of Donovan Thomas's murder"?
I don't remember that. I don't have every single thing that he said during particularly the 9-hour statement committed to memory, but I don't recall him saying that, being even cognizant as to saying that he knew exactly where he was at the time that Donovan Thomas suffered his fatal gunshot wounds.
As it relates to what Kenneth Copeland did tell you about his whereabouts on the day of Donovan Thomas's murder, were you able to get information as it relates to any significant others in Kenneth Copeland's life about where he was on the day of the murder?
Well, so to be clear, I never spoke with Kenneth Copeland, but from the statements that he provided, yes, I believe so. I definitely, because he would reference people that he knew, I sought to identify, for example, phone numbers for those people, because again, that would go to my corroborating his statement based on, among other things, his phone logs.
Okay. When you testified on cross-examination that you were looking at big things for inconsistencies, what did you mean by that?
Well, so, a big inconsistency would be, as I cited, if somebody were to say, for example, I witnessed a murder and there's a video of the vantage point that the person cited that they stood, and then I look at the video and there's nobody there, that would be a big inconsistency that I would seek to clear up. And indeed, I did that here. That's what I meant by that. Something that's glaring, something that you're not able to, something for which there's not a reasonable explanation that can clear this up for you.
You were also asked on cross-examination about who was in possession of the Infinity that was at the Texaco prior to the Donovan Thomas murder. Do you remember that?
Yes.
Why did you say, do you mean, or if you mean actual possession? Do you recall responding
Yes.
regarding actual possession? Why did you say that?
Well, the person that was actually like at the helm of the vehicle and had actual control of the vehicle, not the person that had some sort of legal right to the vehicle through a lease agreement or otherwise.
Did you see anyone else's name on the rental records for the vehicle, the Infinity that was at the gas station up the street from where Donovan Thomas was gunned down?
I don't know. I don't think so. Just Mr. Williams.
Mr. Adams also asked you about phone calls between Demise McMullen, Kenneth Copeland, and Demikion Garlington. In your review of Kenneth Copeland's interviews, do you recall him ever giving a specific time that he was in the car, as in 1 a.m., 4 a.m., a specific time that he was in the car with Demise McMullen and Demikion Garlington?
Well, it was afterward. But no, I don't recall the specific time, or if he cited a specific time. Yeah, from what I remember, he would cite. Generally, he'd say, "Oh, I think it was around 10:30 or something." That's not a quote at all, what I just said. But no, I don't recall him having like a regimented timeline, like at 1927 hours, we went to this location or anything like that.
Okay. You were also asked about the absence of phone calls in the phone records that you obtained as it related to Defendant Williams and Demikion Garlington. Do you remember that?
I do.
Are you able to tell the jury whether the phone records or the call detail records that you obtained would reflect FaceTime calls?
No.
Would those call detail records reflect WhatsApp calls?
No.
Do you know, or can you even say that there was no communication between Defendant Williams and Demikion Garlington?
No, I can't say that. The records, like I said, the call detail records are only those that were logged by the cellular phone company. A FaceTime call would be facilitated through Apple, the Apple Corporation's platform or infrastructure, rather.
Did you ever charge Defendant Williams with Donovan Thomas's murder?
No.
You were asked about the headliner in the Infinity, or obtaining gunshot residue from the Infinity that you found a year and a half later in a different state. Do you recall that?
Yes.
Did you have any information about the number of people who had been in the Infinity between the time that Donovan Thomas was gunned down and the time it was located in a different state?
No. And from what I recall, Hertz wouldn't have been able to provide me with records of that anyway. It's very interesting. I couldn't ask for the rental history on a specific vehicle. I could only ask for the rental history of a specific person.
And did you have any information about the number of times the interior of that vehicle had been cleaned, laundered, or anything else in that year and change?
No, not that I recall. No.
Without that information, why then did you seek to obtain a search warrant?
Well, I primarily wanted to obtain the data from the vehicles, the Infinity's infotainment system, you know, the system that you might hook your phone up to. I thought that if we were able to get a search warrant, we might as well also analyze the interior for gunshot residue. I mean, I was aware of what the probative value of that may or may not be, but I thought better to have it and not need it than the other way around. So that was the rationale there as to why I did that, or was contemplating that. That ultimately never happened.
Mr. Adams also asked you about not getting cell site data for the phone number that you determined belonged to Demekion Garlington, or at least that you testified on cross was Demekion Garlington's phone number.
Well, I don't know that I definitively figured out that that was Demekion Garlington's number. No.
And what information could you get without having probable cause to obtain cell site location data?
You can obtain the subscriber information. That is the information that the phone company has on file for the person that pays for the line, if they have that information on file. You know, the person that they would bill on a monthly basis, basically. And also the what are called call detail records. These are just, I mean, these are anybody who's had phone service, you know, and they've seen a bill and it has a list of your phone calls. Well, that's essentially what this is. It looks a little bit different when you get them pursuant to a legal process like this, but it's just a list of the incoming and outgoing calls and text messages, not iMessages, incidentally, not messages sent between iPhones, but text messages, SMS messages. And that's essentially it. Notably absent from records, call detail records, if you don't have a search warrant, in other words, there wasn't a finding of probable cause, is that tower location data that I've testified to. That is the general area where the handset was, the equipment to which the handset connected to facilitate the communication. Without a search warrant, you cannot get that. You can only get the dates and times of the calls and the numbers that were that were part of that call.
And talking about the lack of calls in those records between Defendant Williams and Demekion Garlington, if two persons or two handsets are next to one another, do you generally expect to find phone calls between those two people if they're sitting, for instance, in the same vehicle?
Well, it's not impossible to call somebody sitting in the same vehicle as you. So I don't know why somebody would call somebody that's saying that. Maybe they can't find their phone. I call my phone, I can't find it. I mean, there could be any number of reasons. I can't speculate as to why you'd call somebody in your immediate spatial proximity.
Who was it that gave you the information about the photograph where Shannon Stillwell is depicted?
Quindary Zachary.
And who was it that gave you the date, or the approximate time or date that the photograph was taken?
Quindary Zachary.
And finally, you were asked about the length of time people remained in jail after being arrested for Donovan Thomas's murder. Do you recall that?
No, I don't recall specifically being asked about the length of time they spent in jail, but I recall being asked about their something along those lines, similar to that, maybe.
Okay. If a person is held on something other than the warrant for murder,
Mhm.
would an MPGJ or a dismissal of the murder charges automatically allow them to be released?
No.
All right, just 1 second.
Sure.
That's all that I have at this time.
All right, is there any recross? All right.
Mrs. Sprinkle, picking up where the prosecutor left off in regards to that NPGJ, what we do know, though, is that Mr. Copeland's NPGJ, the charges or the document that dismissed the murder charge that first put him in jail in 2015, that NPGJ wasn't done until 2017. Is that correct?
That sounds right. I didn't file that, but and I don't recall who the prosecutor was that did, but I was aware of it. But I don't know that he was ever actually booked into the Fulton County Jail on the murder charge, though.
You don't know that?
I think he was in the federal jail, if I remember correctly.
The other three were, though, right?
Well, not Mr. Sledge, Mr. Garlington, because like I said, Mr. Sledge's case was dismissed in January 2016. Mr. Garlington, Mr. Jackson, aka Mr. Stillwell, yes.
Well, let me ask you this. You said Mr. Sledge's charges were dismissed in 2016. Where was he before his charges were dismissed?
Fulton County Jail.
Right, so in jail on that murder warrant, right?
Correct.
Okay, so he was in fact imprisoned on Thorpe's murder warrant until until his charges were dismissed, right?
Well, in the jail, not prison, but yes, he was incarcerated. Yes.
Okay, I mean, jail, prison, you're not on the streets. Your freedom's taken from you, right?
Right. I mean, it's a distinction without a difference. I'm just saying that, prison and jail are two different. Yes, his freedom was restricted. He was not allowed to leave. He was in a government facility.
You were asked a number of questions about cell phones.
Mhm.
And I wanted to kind of pick up there. Now, you were aware from the work that you had done on the case, as well as listening to Mr. Copeland's statements, his interviews, that he had multiple cell phones in January of 2015. You're aware of that, right?
Mr. Copeland did?
Mr. Copeland, yes.
I'm sorry. I have one number for him. I don't recall him saying that he personally had multiple cell phones. I don't remember that now.
How about this? Do you remember in an interview that he had with the detectives where on January the 11th of 2015 at about 3:30 in the morning, where he talks to the detectives about his cell phone or cell phones? Do you remember that?
No, I don't recall that. I know I'm familiar with that interview, but I just don't remember him talking about multiple cell phones or anything like that.
Okay. Are you aware that there are no calls? And if we're just going to just talk about the number that you're familiar with in regards to Mr. Copeland, let's focus on that one. All
Okay.
right? Are you aware that there are no calls from Mr. Copeland's per his cell phone records on January 10th, 2015 between 6:58 p.m. and 7:26 p.m.? Are you aware of that?
I don't have the full records in front of me. I do see that the records that I examined, the last relevant call is at 6:58 p.m.
Okay. And you had, when you got his phone records, we've talked before about the fact that you've got the cell tower data. So you had some idea of where you thought he was at particular times based on those records, right?
Oh, I take that back, actually. At 7:01, 7:23, 7:24, 7:26, 728, 743, 745, 749, 751, and 754, there were calls,
Calls
transactions.
coming in or going out?
Let's see, there was an inbound call at 7:01. There was another inbound call at 7:23. There was an outbound call at 7:24. There was an inbound call at 7:26, an inbound call at 7:28, an outbound call at 7:43, an outbound call at 7:45, an inbound call at 7:49, an inbound call at 7:51, and that's it.
Okay. And so having his records, knowing the cell tower data, you were able to opine on where he was at a particular time on that night, January 10th, 2015, right?
Well, his general where the part of town basically that his handset was located.
You placed him, according to your report, either at or near the McDonald's on the evening of January 10, 2015. You remember that?
I do.
All right. Now, you don't have any cell phone or cell tower data records on Mr. Copeland that shows his phone going to what we've called the Sky House on that night, do you?
I don't recall that. Yeah, I don't believe so.
Nothing in your records that refreshes your recollection that you've got any of that. You don't have any of that to show that he went to the Sky House or his phone, the phone that you're saying is his, went to the Sky House on that night. True?
That is correct. I don't believe that. Yeah, just taking a look at my notes, doesn't appear to me that I found that his phone traveled to the Sky House.
And one of the things that you were asked about these phone records, I think the prosecutor asked you, well, the phone records won't show you WhatsApp communications, right?
That's correct.
Asked whether or not the phone records would show you, or said that they would not show you FaceTime communications, right?
Correct.
And so I think your answer, tell me if this is what you said, was that you can't say that there was not any communication between Mr. Williams's phone and, for example, Mr. Copeland's phone on that night. You can't say that because it could have been maybe WhatsApp or FaceTime, right?
Yeah, some sort of platform that for which we just don't have logs.
Right. And so what we have ultimately is that there is no evidence, none, right? Because we can't assume a negative.
Mhm.
There is no evidence that there was any communication between those phones on that night, right?
Correct.
Prosecutor asked you, said, you never charged Mr. Williams with Donovan Thomas's murder, right?
That's right.
You did not,
That's correct.
because you had no evidence that he committed that murder, true?
Well, yes, but I also can't charge people with crimes. I'm not a police officer and I'm not a grand jury. But I think I understood what the question was intended to elicit. And yes, that's correct. I didn't think that there was evidence to charge him.
You I got a question about a video. I'm not sure if it was a prosecutor that asked you or whether maybe it was Mr. Shard who asked you about a video, specifically at the McDonald's. You didn't get any video from the McDonald's, right?
I did not.
Okay. Are you familiar with different recording systems where there's something recorded and it's kept for a certain period of time and then either recorded over or deleted? You familiar with that?
Yes.
Okay, I think we talked about that a little, or you talked about that a little while ago, right?
Yeah, basically that there's only a finite amount of recording space, so eventually the recording has to start over again.
Now, when we're talking about that, the recording starting over, you said before that some recording systems record for a certain period of time and then maybe a day, maybe a week, maybe 2 weeks, something like that. You remember that testimony?
Yeah, depending on the size of the recording, the size in megabytes of the recording media. I mean, presumably they don't have them on tape anymore. Yeah, it would depend on that.
Right. So if you've got, not hypothetically, but just based on your knowledge and your experience, right?
Mhm.
A system that records every 2 weeks. It's not that you've got 2 weeks of recordings, then all of a sudden that goes away and it starts over, right? Isn't it just that you have one day and then a particular day is taken up by the following day as it starts and goes all the way through? You understand what I'm asking you?
Yeah, I think I understand. We say it's a hard drive that the data is being written to. So, I mean, I don't know that as the drive fills up, you're right. I guess what you're asking is that after 2 weeks, does all the data just immediately go away at the 2-week mark? No, I wouldn't think so. No, I would think it would be an incremental deletion.
As it relates to this, if there's not knowledge, I would object based on speculation as to any particular.
Sustained.
All right. Mr. Sprinkle, you were asked, I think following up on a question I'd asked you, then the state asked whether or not you were aware of if Detective Thorpe consulted with Detective Dennis or Gaither. Remember that question?
Yes.
And we had talked earlier when I questioned you originally on cross about the fact that you knew that there were interviews, for example, with Mr. Copeland, where all of those detectives were present, right?
Yes.
And those would have been things that took place after January 10th of 2015, correct?
Yes.
As the murder investigation was being conducted, right?
Correct.
Okay. Then we have the arrest of these 4 individuals on October 20th of 2015, right?
Correct.
Okay.
Well, I don't know that they were all arrested on that date, but that was the date the warrants were obtained.
Got you. That's the date that Detective Thorpe made a decision, and I'm gonna arrest these 4 guys or get a warrant for their arrest, right?
That's right.
Okay. Which he was wrong about, right?
Well,
Sustained.
Okay. You were asked whether or not you thought that, or you knew whether Detective Thorpe sought permission from either Detective Dennis and or Gaither to swear out the warrants for the arrest of the individuals in the Donovan Thomas case.
yes.
Right? I think your response was either you don't know or you don't think he did.
Well, no, I don't think he did. That'd be very odd. The permission lays with the magistrate judge or a judge, not with his coworkers at the Atlanta Police Department. But to my knowledge, no, that never happened.
But what you do know from speaking to the detectives, and by the time you grab a hold of the case, right, is that certainly Detective Gaither and Detective Dennis had been involved to some extent in the murder investigation, right, or at least assisted with it, right?
Yes.
And after Thorpe swore out the warrants in October, they were aware that these 4 people were sitting in jail, right?
They were.
Neither of them, these 2 seasoned investigators, either came to Thorpe or you and said, hey, you know what? We got some problems here. I think we got Detective Thorpe didn't do what he was supposed to do. We need to take another look. That never happened, did it?
Objection, relevance, and vague and compound.
Sustained.
Okay. In regards to the Infinity, we talked initially, I questioned you, not talked, about possession of the Infinity.
Mhm.
And you used the word actual possession.
Right.
Right. You said, no, I do not know who was in actual possession of the Infinity on January 8th, 9th, 10th.
Right.
Fair? Okay. And you were just asked a question about the importance of actual possession. And actual possession is something that's important to you or was important to you in making a determination about the Infinity, right?
Yeah, that's right.
Right. Mr. Williams's name appears as the person who the car was rented to, right?
Yes.
Right. Now, in terms of your investigation, if you believed that there was something that was done or crime committed using the Infinity, right, that is why it would be important to determine who was in actual possession of the Infinity at the time that the crime was committed, right?
That's correct.
Because I can rent a car and it be in my name, but if someone else has possession of the car and is committing the crime, they're the person that's committing that crime, right?
That's correct. I mean, unless I were able to show that somehow the people that actually possessed the car did so with the encouragement of the lessee. But yes, you're right.
And specifically in regards to this case, this Infinity, Mr. Williams, you had no such evidence. True?
That's correct.
Your investigation, I use the term investigation, your work on the case led you to recognize that there were inconsistencies and you couldn't trust what Kenneth Copeland was saying or what he had said in his statements. True?
Well, no, I know. I thought that his statement, there were a number of things that I thought were accurate about his statement.
And some things were inaccurate, right? As far as you knew.
You would have to, his statement was there was a lot in his statement. I tried to look at his statement generally based on what he was able to remember when he provided that 9-hour statement, and primarily compare it with the phone records. And when I did that, I didn't see any glaring, I can't recall seeing anything that was just wholly inconsistent or impossible. Like, for example, the first witness, Spencer Wright, what he said happened was impossible. He wasn't there. I didn't see anything like that with Kenneth Copeland.
Did your investigation on this case, by the time you picked it up or got involved in it late 2015, 2016, seeing everything that had been done or not done thus far, also lead you to believe that you couldn't necessarily trust the investigative work of Thorpe, Gaither, and Dennis?
Well, no. I mean, yes, there was Detective Thorpe made a mistake in not taking a look at the video and checking to see if the witness was actually where he said he was. Okay, but would that mean that I wouldn't be able to trust anything in the entire investigation? No, I wouldn't make that sort of blanket condemnation such that I would just disregard everything in the entire file and every finding of fact made by the police. No. I mean, I can see that a mistake was made in one part of the investigation, but there are other parts of the investigation that were not as erroneous.
His mistake put people in jail, though, didn't it?
Yes.
That's all.
All right, any other defense attorney have redirect? I mean, I'm sorry, not redirect, recross?
No, Your Honor.
Okay. All right, Mr. Sprinkle, thank you for your time. I think it sounds like we might see you again at another stage in this case, but you are free to go for now.
Thank you, Your Honor.
And it's a little after 4. Do we have another witness who's going to take hour and a half? If not, we'll just get started with somebody and go as far as we can.
We'll get started with
Okay.
Detective. Yes.
All right. Anybody need a break before we get to the next witness? Y'all good? Okay.
Your Honor, and as it relates to this particular witness, there's been a ruling as it relates to filming.
Okay, so no filming of this witness. Thank you for that reminder. All right, we can go ahead and get that. A quick bathroom, like 5 to 10 minutes. Okay. All right, try to be fast about it. We'll be back at 4:15. And is the first system operational again? Okay, do you need to switch it back over at all? Okay. All right. It's fine, as long as it's not going to cause us problems. And to use the primary system, it seems like it's back up and working again. All right. Well, I mean, you're the one who also wanted a restroom break, but I can listen.
And thank you. So, Your Honor, I'm objecting to a wholesale playing except for what the court redacted from Mr. Zachary's August 5, 2017, 2015 video audio recording interrogation. And there's Georgia cases that I have at my fingertips as well, but the first one is L as in laughter, K as in kitten, L as in laughter versus Ellington, Ellington. Your Honor, it's 2018 United States District Court, Lexus numbers 208774, decided December 10th, 2018. And in that case, the district court wrote that the trial court ruled that because AL's statement during it's CAC, but Child Advocacy Center interview were hearsay, and the prosecution had not introduced the interview, counsel could only introduce those portions of the interview where AL made an inconsistent statement, not the entire interview. And that's what I'm saying. Here, the state, and I raised this at your bench 3 times. I said what I foresee is that the state is not introducing the interrogation, either one, there were 2. They're going to not use Mr. Zachary, and they're going to put it up with another witness. And you said, we'll see what happens. We'll see what happens in the future. Well, that's exactly how it played out. And it is my opinion that if there are true then I understand that. And it comes in under 24-8-801 D1A, because it would not be hearsay, because it would relate back to OCGA 24-6-613, prior inconsistent statement. But the state does not have a Kenneth Copeland where he would just say, yeah, I don't remember if I said it, but I lied. They have Mr. Zachary saying, I said that. I am a liar, but I said that. And that's different than the just, I'm a liar, I don't remember, I don't recall. So unless the state can go piece by piece on what is an inconsistent statement, I'm objecting to just having a trial by prior recordings. The state then puts it on the accused and said that, well, we objected to it taking so long, to the state going through the entire interview. The state was asking about, how old are you? Do you have a brother? Where do you live? I mean, all this just page by page, but they did not hit the specific statements that are now deemed inconsistent statements. And I'm objecting to the wholesale playing of a recording and the witness is gone. That's my objection. I have a Georgia case too, and that is Gibbs, GIBBS versus State 340, Georgia Appeal 723. It's in Division 2A, as in Elisa, 2017 case.
All right, thank you. Ms. Love.
Your Honor, I believe that the court accurately surmised that the testimony of Quindarius Zachary was given the way that he testified and what he testified to, much like with other witnesses in this case, he has set up where he has denied with the state information that he gave in the interview. He has claimed to not recall information that he gave in the interview. He has claimed to have lied about specific information that he gave in the interview, even to the extent that when asked identical questions by opposing counsel, he would give a completely inconsistent answer to opposing counsel. For instance, do you know this person? To me, he would say, I can't recall. 5 minutes later, to Mr. Steele, he might say, yes. Or to me, he would say, I can't read. 5 minutes later, he's reading a book placed in his hand. So, Your Honor, I think that the court had it right. I would ask that the court allow us to present to the jury this pertinent information and relevant evidence.
All right. Yes.
I just respond. The part I disagree with is the state has already presented this evidence. When when he's asked, did you say Shannon confessed? And he says, yes, I did tell the police that, but that was a lie. They've gotten that information out. He has confirmed that he told the police that back in 2015. And that's the whole point of using extrinsic evidence, as I understand it. The whole point of using extrinsic statements or prior statements to prove the point. It's when the person's denying it and you have to bring in that statement. I'm sure if we look at the transcript, there are going to be a few times, especially towards the end of, I believe, the second day where Mr. Zachary was frustrated and got into I don't recall mode. But other than that, he acknowledged what he allegedly said and said it was a lie, and this is why I lied. And I don't believe that lays the foundation for what the state wants to do.
Okay, so I think that by and large, he said a whole lot of I don't remembers and a fair bit of if I said that, I don't remember saying it, but if I did, I lied. To the extent that the statement itself can come in as substantive evidence as a prior inconsistent statement. And if the defense has particular parts of the statement that you believe that actually were sufficiently handled such that the extrinsic evidence of that shouldn't come in, then please let me know. But I think by and large, it can come in, subject to the redactions, of course.
Can I respond to your request? He certainly acknowledged making statements about Mr. Stillwell allegedly confessing. In both statements, and the reason I can remember that is because I went through them and talked about how they differed, but that was standard impeachment comparing two statements, but at no point did he deny making those statements. So I think that's pretty clear that he did not deny those. He also did not deny giving when I believe it was Miss Love leading, or I shouldn't say that. Miss Love was asking questions and getting into alleged facts that Demekion Garlington allegedly said. I believe that Mr. Zachary acknowledged telling the police about that as well, except he just said that, Garlington was a play. Garlington had given him the play was his ultimate explanation, but I don't believe he denied that either. So I think, sure, there's a lot of tangential points that perhaps a foundation was laid, but on the main points as it relates to Mr. Stillwell, at least, I don't believe that he denied making those statements. And therefore, I don't believe it's appropriate to play the prior inconsistent statements because they are not inconsistent.
By the same token, Your Honor, he also did not deny having said in his previous interview that Mr. Kendrick had admitted to being involved in that murder. He said that it was a lie, but he did admit to having said that.
All right, I'll consider those over the break.
Your Honor.
One more, Your Honor.
Yes.
He admitted that Jeffrey Williams, that he said, Jeffrey Williams gave me a new vehicle to Shannon, allowed Shannon Nard grew up, drive as well as Mr. Copeland. And he was never even asked about giving Jeffrey Williams a gun, so it can't be inconsistent. Asked about that. Those two items I object to.
Asking about giving Jeffrey Williams a gun.
Yeah.
Give me a
Never
little bit.
asked about that. And it's in his statement to the law.
About Zachary giving Jeffrey Williams a gun?
Yes. But he never was confronted about that.
Okay.
Your Honor, now that I think about it, he also acknowledged giving the statement to law enforcement about, well, yes, he acknowledged giving the statement to law enforcement about Mr. Copeland being at Big Boo's house and then saying, let's go, and then returning and learning that there was a price paid on it. He acknowledged saying all that. He said he made it up, but he acknowledged saying all that. And he also acknowledged telling the police about what he observed at the Lil Wayne bus shooting when he was at Club Compound and cars leaving from there. So all those things were touched upon on his direct and acknowledged by the witness.
Your Honor,
Yes, ma'am.
saying that he told the police that and then saying, but it was a lie, makes the prior statement an inconsistent statement. Additionally, he said to the state, I was high on, or I was withdrawing from 3 or 4 different drugs, depending on what time he was talking about it. So his intent was to suggest to the jury any way he could that anything he said about and I specifically asked because anything he said about either of the 3 defendants in this case that he talked about, he denied were true. Everything.
Okay. Let's take our 10-minute break, which at this point will bring us back at 4:30.
Choke, no joke. I'll be back in a minute. All right. Thought we had a mistrial, man. We back, y'all. We back. Remember, we was a little behind. Now we on time.
My friend Kamala is coming up on one of the last major
We
fundraising
don't
deadlines
care.
before Election Day.
We don't care.
So when I
Barack.
say that you're
We
going,
don't care, Barack.
Yeah, I'm really thinking it's 4:35 right now. Can you go ahead and let the jury go for the day? We'll see them at 9. We can just discuss some evidentiary issues for the rest of this day. A couple of them might need to get their things. I don't know if you want to just grab their blankets and things. We will be starting at 8:45. Can somebody else do that? Because I'm waiting for Mr. Steele to get the reference, so I think you need to be here for that. Somebody else can go say that. But the witness needs to be here at 9. What is it, Mr. Steele?
I believe it's on page 149 of 275, line 16, and it's a lot of unintelligible. This transcript is not good. It's unintelligible.
No, it's not.
When I listen to it, it says, I told Bud and stop messing with everybody. He might find no guns for no crime. So I know it doesn't sound bad, but I believe that later they say that he bought a gun for Jeffrey. And that's what I'm looking for. And if it's not there, Your Honor, then that's the only reference.
Any response on that? I mean, I don't recall that witness being asked anything about that, but it's not really saying anything anyways, is what Mr. Zachary's saying.
Yes.
Judge, I know that the line 19 is out, and I just ask that the court allow us to play it up. What I have is that he said, that I'm looking at it. I know that I disagree with with Mr. Steele about it, this particular sentence needing to be put on him. He said everything he said about each person in this courtroom is not true. And so this is not one of the redactions that were previously ordered. I think
Hang on.
it's admissible, and I'd ask that we be allowed to play up until line 18.
So that's not Zachary saying anything about Mr. Williams, right? It's just him saying, here's what I said to Mr. Williams.
No, it is that Mr. Williams didn't have buy any guns to commit
Hang
a
on.
crime. Sorry.
Okay, go ahead.
Mr. Williams did not buy a gun to commit a crime. That's what it says. It's exculpatory, I understand, but it was not asked about, is what I'm saying. So it's not an inconsistent statement.
Read the entirety of what you think it says
Okay.
for me. Oh my gosh. Okay. I don't know why they keep opening that door, but it's closed now. I think you said that you thought it said, I told thugs, stop messing with everybody, like, don't buy no guns for no crime.
No,
Okay.
that's not what it says.
What
I
does
can't
it say?
Find my page that I lost. Does anyone remember the page I?
Bless you.
Your Honor, it's what he says, according to the audio.
It's Mrs. Zachary. I have 149 again, and it's Detective Dennis saying, so they just got sticks on deck, meaning guns?
Right.
No, where they getting them from? Thug got a check, so it's not put a date on this and it's unintelligible. Then the next person says thug. Mr. Zachary says thug. And then Mr. Zachary said, I told thug had to stop messing with everybody. He like buy no guns for no crime. That's what it is. Then the next line is out because it's about this illegal search of Mr.
Right.
Williams' home.
All right. I mean, I think given my ruling, when Miss Love was doing the examination, and I told her, stop going line by line, that I'm gonna permit that to come in. With regard to the rest of your specifics that the variety of you raised right before the break, where Mr. Zachary acknowledged saying something, but then said it was a lie. That does not prevent that from still coming in as a prior inconsistent statement under 613. I mean, he's given an opportunity to explain or deny. He doesn't deny, he explains it by saying it's a lie. So the prior statement is still a prior inconsistent statement and can come in. So when we start with Detective Gaither in the morning, that'll be my ruling with regard to all of that, that it can all come in subject to the redactions that were already made under 613. Okay, so a couple of questions about, oh, did we ever get Ms. Love, you were going to provide us with the specific parts of that? Mr. Zachary's Twitter that you wanted in?
So I do have some, but since I didn't push with getting them introduced with Mr. Sprinkle this time, I instead.
Right, but we still want to know what they are, so
Oh,
we'll
yes.
know what needs to be dealt with.
Yes,
So
sure.
can you tell us what they are?
Yes, so it was page 32 of 259. And what I'm going to do, Judge, is just scan them all. It's page
Okay.
32 of 259. Page 63 of 259. Page 64. 66. 74. 79. 81. 86. 87. 92. 12, 15, 142.
Hang on, 12, 15, what does that mean?
That's the page number 12, page number 15. I had,
Oh, so we're going back. So before 32, page 12? I'm just confused.
yes, it was. It
Okay,
was, I
so
had
page 12.
just
and-
begun.
All right, and then what?
Page 12, page 15, page 142, page 131, page 128, 129, 127, 126, 122, 119, 117, 100,
that it?
Page 3. And like I said, I was scanned even for page 109. 175. 192. 198. 204. 220. 221. 240. And Your Honor, at this time, that's what I have to present to the board. I asked the court to allow me to just scan any additional ones in that 140 chronological PDF.
A chronological would be wonderful. And then share that with everybody. And you now intend to introduce these the next time Mr. Sprinkle testifies, which will be how long from now?
Probably not this week, given the, not,
After we get back from our.
yes,
Okay, after the non-jury days.
yes.
Okay. All right. Then that'll be yet another item for us to take up during our non-jury days. Okay, Mr. Steele, I have a question about your motion in limine number 61. In your paragraph 4, you raised the issue of text messages captured on the wiretap. Are there text messages captured on the wiretap?
There are line sheets. There are line sheets that write in proposed text messages, and I believe that that would be hearsay.
Line sheets that write in what?
So line sheets that the agents create, and they're doing the minimization. And then on that, they have text message and they write what the text message is, but that would be hearsay.
Okay, right, I'm sorry, write that in. There is a text message or the substance of a text?
Substance, the actual substance of a
Okay.
text message. And under the case I cited,
Yeah. I mean, I looked at the case you cited and it doesn't seem to have a holding on much of what.
best evidence rule.
Okay, I couldn't quite tell the purpose for which you were citing that. So you're basically making a best evidence
That's true.
objection to these. Okay. I was trying
That's
to
true.
Sort out what your objection was. Okay. All right, so that'll be something that the state will need to address. But you know what the objection is now. All right, with regard to the rest of it, I mean, I've already made a ruling that the text messages through, it was just the Verizon person anyway, that they are sufficiently authenticated that you can certainly argue to the jury. And it's ultimately up to them anyway, but it's a prima facie case for authentication and that's been made. And it is not accurate that it's already been proven that those text messages are not verbatim. What the witnesses testified to was that they may or may not be verbatim, not whether they are or not. That it's possible that something might not be verbatim there. But anyway, with regard to authentication, they have been authenticated, so I'm not going to exclude them, and that'll just be an argument that you all can make to the jury. Okay. And then we'll circle back on the best evidence with regard to the wiretap texts. Okay. Your motion in limine 62 deals at this point with Mr. Kendrick's guilty plea potentially coming in and Mr. Ryan's conviction potentially coming in. And I don't know, we had discussed before that if that did happen, that there would at the very least need to be a very tight limiting instruction about that. And I don't know if it is the state's intention to introduce either of those things. And if they are arguing that they can come in against anybody other than Mr. Kendrick for his and Mr. Ryan for his, or what the argument is. So can you elucidate us on that so that I know what I need to be thinking about?
Judge, I agree that there needs to be a tight instruction, and I just asked for the opportunity to submit a proposed instruction.
All right, but you agree that it's a confrontation clause issue with regard to it coming in against anybody other than the person who was convicted of it, right?
With respect to the plea, definitely, and with respect to the conviction, probably. And I'd like to look that up. I want to make sure, but definitely with respect to the plea, because that's a statement that he's making.
Okay, well, it's equally clear with regard to the jury conviction. So you can look it up if you want to, but it is a confrontation clause issue with regard to it coming in against anybody else. I don't know when that might happen, but
Not before we come back into.
okay. I'm still trying to make a determination. Okay, so I guess that's the only argument right now, is that it's a confrontation clause issue, and yes, it is. So at most, it could come in against those specific people with a tight instruction, and I'll see if anybody else raises anything else.
Okay, and I tried to craft an instruction, and I can't do it because I don't believe that it passes intellectually to expect anybody, a lawyer, to really hone in and say, okay, I'll just use this against Mr. I'm not picking on, but Mr. Kendrick for this purpose. And yes, I could use all the evidence against everybody in count one, but not that one piece of evidence, but I'm going to use it against Mr. Kendrick. And by the way, in that indictment, it says gang YSL, but I'm certainly not going to use that as an admission against anyone else. So I gave up on an instruction.
All right. So, I mean, yeah, there's definitely a potential danger there. So if we don't come up with a good enough instruction, then that stuff can't come in. So it's incumbent upon the state to present something that's workable. All right. And then on the motion limiting number 63, I'm not going to go through the specifics of that one right now. It's pretty detailed. But that's another thing we're going to have to go through. Now, in terms of, and I don't even know if Ms. Good is going to testify or not, but I guess you're not limiting it to Ms. Good. You're saying these portions shouldn't be used with any witness, right?
That's true, unless it's better than, I heard from my cousin who heard from this person. That's how it comes out.
Okay. So now you actually say from asking questions and playing for impeachment, which that's one thing, or to refresh memory. And I mean, if you're refreshing memory, you're just presenting it and they're supposed to be looking at it silently. And I think something doesn't need to be evidentially admissible to be something that could refresh somebody's memory. So I
was once trying a federal case and the witness couldn't remember. And the prosecutor, U.S. attorney, wrote down a piece of paper in his pen to refresh the memory, and I objected. And the judge sustained it, but said, actually, it does say you can refresh memory with anything, but the judge did still sustain it. But
Well,
my point is, yes, I understand, but it's inadmissible anyway. So I was focusing on some are good And why would we refresh memory on something that's not admissible? So that's
Because
what
it
I
might
was-
refresh their memory.
about something that's not admissible.
So, I mean, they may not then be able to testify about it, but I'm
Very
not going to limit them in what they can use to refresh somebody's memory.
All right.
The
Except
rest of it we'll take up later.
for a lawyer writing it out on a piece of
Well,
paper.
you know, if that happens, we'll take it up at the time, but I suspect my ruling would be the same as that judge's. Okay. I just want to inquire, because it's been quite a long time since well, I did more than suggest. I ordered the state and counsel for Mr. Ryan to get together on what they could stipulate to and what they agreed, what maybe not stipulate to, but what they agreed was in and out with regard to all sorts of different evidence. Have y'all done that yet?
We
Okay, great. So y'all be able to present that when we get together early next week. I'm trying to think what else we need to think about or could discuss or could get out of the way right now.
Have that hearsay, double hearsay matter.
Are we ready
wiretap.
on that? I mean, it's been a while too that we were going to take that. That was, we had kind of gotten stopped on one of the wiretap things. Maybe we won't get bogged down in that right now. So I had asked a while ago for,
Let's get real. Your butt's not perfect, but at Orgain, we love them all. We love Ricky the Rump.
Love you back.
Bubble Butt Bobby.
That's me.
Laura Longcheeks. Tara the Tush.
I had asked, and I know y'all wrote briefs, but did anybody come up with, and Mrs. Bossy said she couldn't find anything, but has the state been able to come up with any case law where that's kind of factually in alignment? Or,
So not on all fours, but I
Okay.
did find cases that's in terms of the way it's just outlined here, but I did find cases that spoke to the admissibility of overt acts that occurred after and the admissibility of overt acts that were not included on the indictment. But
that was what was in your brief though?
I
Or
think additional ones too.
Okay. Do you mind just maybe sticking those in an email with the sites and sharing those with everybody?
No, I do not mind.
Okay, that would be wonderful. All right. Anything else?
Your Honor,
Oh.
I just wanted to put a couple things on your radar. I also filed a motion similar to Mr. Steele's regarding witness good. Just so,
Okay, I
that
did
was
not see that one.
that was filed today. I just emailed it to Ms. Percival.
Okay.
It's been accepted today, but the other thing I was wondering if the state could just tell us where, I assume at some point in the near future, we're going to discuss these Twitter records from Mr. Zachary or whatever they are. I think they're
Right.
Twitter. Could you just tell us where in the discovery they are?
Yeah, yeah, she was gonna resend the link. What's easier?
I sent it to people internally and they had problems opening it, so I.
Okay, do you know which discovery tranche it was shared in?
No, not the discovery tranche, just the link for them, but I know that, I'll do a search in Dropbox for.
Were they served in discovery?
Everything else in the file that it came from, including attorneys.
I don't think they can hear you. pull the mic to you.
I believe that they were, considering the fact that the entire file that they came from was served, inclusive of notes, internal emails and the like.
Okay. All right. Okay, so if everybody can just do the things that we all just talked about, I'll see everybody at 8:45. Thank you. Yes.
There was one matter that I believe the court had said that we were going to revisit.
What was
No?
that? I don't know.
Your Honor, I just wanted to briefly, when one of the upcoming witnesses is Agent Bernie, who did the cell site tower analysis.
Okay.
And so I think this was back in August. One of the events was the shooting of the tour bus on April
Uh-huh.
of 2015 of Mr. Carter. And so I told the court and defense counsel to give them time to digest that analysis because it happened after that act's testimony. So the state would prefer to, because it's the same calendar year, it's 2015, to walk through those slides with Agent Bernie when he testifies. But I
Mhm.
wanted to, make sure that with the court's prior discussion now almost 2 months ago, before ask him any questions about that. And so I wanted to just raise that now. Your
Okay.
Honor.
Any issue with, is it Detective Bernie? Agent Bernie, Special Agent Bernie, testifying to that incident as well, the phone records with regard to that incident? Y'all had him for a good bit of time now.
I have the phone records. I'm prepared for it, but it is cumulative. But I made this argument to you before, and I believe you said that, or the state said that Agent Racy was challenged as to his qualifications. That challenge was overruled, and he testified fully about it. We went on, and I don't remember how long, but day with the state putting down on a pad in front of the jury all these different calls and all these circles and diagrams that the state brought in. So I still maintain it's cumulative, but I asked you that before, and you said that you would allow him, my memory is you'd allow Agent Bernie to testify, but not to go through the whole thing again. That's how I remember it. And if I'm wrong, please correct me, Your Honor, or anyone else. But I really don't want to sit here again and do the whole thing. And I don't mean that to be curt. It's just, it's inappropriate to keep redoing the same thing because I didn't challenge anything about Agent Bernie for that shooting.
Okay, y'all understand the parameters?
Your Honor, I do understand the parameters,
All
and
right.
the state's intent is to, with Agent Bernie, that slideshow that I'm referencing, that he conducted, that's going to be the extent. The state's not going to be rehashing ground that was covered with Detective Racy.
All right.
The August 8th, that Dropbox link, it's in Special Agent Bernie's subfolder. No, and what I just sent, Your Honor, to be clear, there was a toll analysis that Agent Bernie did. So there's an Excel spreadsheet that was in that August 8th Special Agent Bernie. The state visually, there's some physical boards printed right behind that witness stand that we did with Detective Racy. It's the same data. Phone X called phone Y for 30 seconds at 7 o'clock. Phone Z called phone S, on and on. So the Excel spreadsheet, that those same calls, the same data that Agent Bernie conducted is visually is being printed on physical boards. So
Okay.
they're not physically built, but I sent the template that our graphics team is putting that information on. So it's the same information. It's just going to visually look a little different than just an Excel spreadsheet.
Okay. All right. So tomorrow we'll have Detective Gaither and then who? Okay. So those will be ready by tomorrow then?
That is, yes, Your
They
Honor.
either will or they won't be.
Correct, Your Honor, correct.
Okay. And then is that going to carry us through the day? Those two witnesses? Okay. And then the next three, this is the same crime scene tech, Jenkins, and then Sanchez and Lewis. And will that get us the whole of Wednesday?
What time did the court say that we were ending court on Wednesday? Is it 5, the normal time?
Normal time.
Okay. We believe that it will, given the length of time that these two witnesses are, but if they don't, we would,
You'll be able to evaluate at lunch and scramble and get somebody else.
no, we'll call probably Mr. Sprinkle.
Oh, okay. As long as you got somebody. All right. Okay.
I have the location for where it was served.
Okay.
tweets. It was served in Discovery 1-2 back in July of 2022. If you're looking at the consolidated discovery, it would be in folder 1, counts and indictment by act. The next folder, acts 16 through 20, count 2. Then the next folder that says count 2, 16 through 20, discovery 1 to 2. Then the next folder will say social media. The next folder will say Quindarius Zachary, or Zachary, Quindarius.
All right. Thank you. And Ms. Love, can you, like, in the next hour to hour and a half, get us the chronological scanned
Yes.
parts that you actually want
Yes, thank you.
published? Thank you. Okay. Okay, and then, Mr. Shart, I'm in receipt now of your motion limine with regard to Ms. Good, and we'll take that up during our non-jury days as well. Okay, anything else? All right, anybody? All right, I'll see everybody at 8:45. Thank you.
All right, y'all. I'll be back later. I will be back. Peace.